Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today may be the day I earn your subscription. For today's content, we are doing yet another video from Dr. Todd Grande, who has some comments regarding the Kim Potter trial. Kim Potter was a police officer in Minneapolis who pulled over Dante Wright as part of a routine traffic stop. The traffic stop went bad. Dante tried to resist arrest. He got back into the car. Kim Potter yelled, "Taser, taser, taser," shot Dante Wright, and has been convicted of first and second degree manslaughter. She is facing up to 15 years in prison as a result of all this. Well, Dr. Todd Grande wants to comment on some things, so that might be fun. So we're going to pick this up at about the 4 minutes and 50 minute mark. For the first 4 minutes and 50 minutes, for the first 4 minutes and 50 seconds of this video, he lays out the case, lays out a little bit about the history, about the people, their backgrounds, and all kinds of stuff. But you all know all that already. So we can skip all the background stuff and we can just start with, him talking about things and me commenting about the things that he's talking about. So let's do that.
Prison, considering that she does not have a criminal record, a typical sentence for this charge would be about 7 years. Now moving to my analysis. The wording of the manslaughter charges in the state of Minnesota is nebulous and confusing.
The wording of the statutes are neither nebulous nor confusing. They are actually fairly well-defined terms. As one might be able to appreciate, murder is kind of the first crime that we as human beings tried to define probably ever. And so it is one of the more well-defined crimes, not to say that it can't have nebulous components at times, but the wording is not nebulous. It has meanings that are well understood, meanings that go back in law basically as far back as you like, particularly when you're talking about murder statutes, which then again, we're talking about not only English common law, we're talking about since the concept of law was invented, ever. These concepts go pretty deep. They're not nebulous. The terms are understood. And to the extent they are nebulous, which they're not, there's many cases that are defining these terms in somewhat excruciating detail, especially, again, on murder, where it's something we've tried to decide. Now, of course, this is manslaughter, but that's just a different version of murder, right? Murder comes in many different varieties, in many different forms. First, second, third degree murder, manslaughter, criminally negligent homicide, vehicular manslaughter, vehicular homicide, and other versions I can't even begin to remember. Murder comes in many different versions with different names, with different penalties and different kinds of culpability and different terms. But it's something that the law has spent quite a bit of time trying to define. It is not particularly nebulous. Unlike, I would like to argue, psychiatry, for example, where because of the inherently subjective components of psychiatry, it is a little bit more nebulous, at least it seems to me, because you're talking about what's going on in someone else's head, which is a little bit harder to define in any sort of way. But, we'll press on and, yeah.
To be convicted of first-degree manslaughter, Potter must be guilty beyond a reasonable doubt of causing Wright's death while committing a misdemeanor, specifically reckless handling or use of a firearm. So the key word here is reckless. In order for the act to be reckless, Potter must have committed a conscious or intentional act in connection with the handling or use of the firearm. To be found guilty of second-degree manslaughter, Potter must have caused Wright's death through culpable negligence, which means she created an unreasonable risk and consciously took a chance of causing death or great bodily harm while using or possessing a firearm.
Now, I have to give credit where credit is due. These actually are not too bad in terms of describing first and second degree manslaughter, which again will vary from jurisdiction to jurisdiction. So these are pretty reasonable definitions of it in Minnesota. Your mileage may vary to some degree in other states. The things that here is describing, depending on your state, may not be manslaughter, they might be murder, they might be called something else. They could be a lot of different things. These concepts are codified in different ways. But that's okay. We can just focus on Minneapolis and Minnesota for just a moment and talk about what was actually going on in this particular case, not all the cases. Make it a little bit easier on ourselves, right? So the first degree manslaughter in this case means that the prosecutors alleged that Potter, or in this case convicted Potter, of causing a death while committing a misdemeanor, namely the reckless handling or use of a firearm so as to endanger the safety of another. And this could be any other, not just Dante. Could be the fellow officers, for example. With such force and violence that death or great bodily harm to any person was reasonably foreseeable. So reckless handling of or use of a firearm in first degree manslaughter, you have to have the underlying charge. In this case, it's 5th degree assault, I believe, as memory serves. And the second degree manslaughter is by culpable negligence, meaning caused a unreasonable risk and consciously took chance of causing death or great bodily harm, in this case while possessing a firearm. So the two charges are very, very familiar, or very similar, I should say. They're very similar in the way they're constructed, at least in terms of their application into this fact pattern. So we have the same facts, which allow for basically a charge of first or second degree manslaughter, or in this case, why not both? Now, you can only be convicted of the thing once. So it's whatever's greater will win the day in the end. You can't be punished more than once for the same crime. But you can be convicted more than once of the same crime on different theories of the crime. So here we have two different theories of the crime. In second degree, that we recklessly handled the firearm. In first degree, that we committed an underlying misdemeanor, in this case an assault, and that itself requires the reckless handling of a firearm. So they're very, very similar. But, law has that sometimes. We got two different charges that sound very similar. The same fact pattern allows for first or second degree or both. They charge both. They're convicted of both. You can only be sentenced really as a practical matter to one. Whichever one is greater wins. So that's what we've got going on here. These concepts are not particularly novel or strange in Minneapolis. As I said, the law of murder goes as deep as you like. And these are concepts that we well understand. When we talk about recklessness, when we talk about culpable negligence, at least to lawyers, we understand what we're talking about. It is not novel concepts. So, fair enough. Let's press on.
So even though culpable negligence is easier to prove than recklessness, both charges contain the word conscious.
Right.
Much of this case was hinged on how that word would be interpreted.
So yeah, I've taken the view, and so have other lawyers on our sort of group panel, that that culpable negligence is basically recklessness when you actually look at what it is, right? The conscious disregard. When you have negligence, you don't have to have conscious disregard of negligence. That's one of the things that separates negligence and recklessness, right? Negligence is you have a duty and you breached your duty in a way that caused harm. You don't have to be conscious of you having the risk. You can be somewhat unconscious. Your run-of-the-mill traffic accident is negligence. You don't have to have any particular mental state that you're causing any particular risk. It's just that basically in the case of a car accident, you weren't paying sufficient attention and you're required to pay sufficient attention. So in that case, the breach of your duty is failure to do something, namely your failure to pay sufficient attention. And your duty to pay attention only results in this negligence. Recklessness requires something more. It requires conscious disregard. So you're causing a harm. You're actively aware you're causing harm. You may not necessarily know exactly what harm you're creating, but you know. And the example would be driving while intoxicated. In this case, by the way, the intention is to take the alcohol, right? So you took the alcohol with the knowledge that it could lower your mental state. So you took it with that knowledge. Then you decided to drive, and you should realize that some harm could be foreseeable. That is a classically reckless action. So that's kind of the difference between the two.
In order for Potter to be guilty, she must have engaged in a voluntary act. If
Right.
it was reflexive, that is not enough for a conviction.
See, he's getting it right? It must be a voluntary act. She has to consciously, with a mental state, she has to consciously disregard the risk. She has to be aware of the risk and consciously disregard. If she's not conscious, if she is not doing it with some kind of deliberation, then it's not reckless. It might be negligence, but that's not what the statute means by culpable negligence, because the statute itself goes on to clarify that you have to have this conscious state, this conscious disregard. That's what it means by culpable negligence, as opposed to just regular garden variety negligence, in which case we're talking civil law.
Both the prosecution and the defense agreed that Kim Potter intended to use her taser.
Right.
So even though she acted voluntarily, she didn't believe she was holding a firearm. No one is saying that her use of the pistol was intentional. Now,
Correct.
if one can somehow get past the wording of the charges,
the man says if one can somehow get past the wording of the charges. The man says if one can somehow get past the wording of the charges. It's been a long time. Excuse me. Okay. Let me help you out here, Todd. Let me help you out here, Todd. The law is prescriptive as opposed to descriptive. What do I mean by that? Well, my perception is that psychiatry, for example, as a field, is descriptive. The DSM, for example, and the words that it uses are trying to describe something that is a real, actual condition in someone's brain. It's like, this is a condition or a neurosis or psychosis or whatever the terminology is. It is trying to describe something that pre-exists. It's descriptive, right? So it is trying to use language to reflect an underlying reality. But the underlying reality itself is what's important, not the language used in psychiatry. So, for example, the DSM and its definitions have been modified in the past, and I'm sure will be modified in the future. And of course, the DSM isn't the only guideline out there. There are other things that are written by other people. They're trying to all reach for something in various word formulations to varying degrees of success. But it's trying to describe this ethereal thing, this mental state, the Platonic chair, if you like, trying to describe it in words. And they're all trying to reach for this thing that exists in a pre-existing condition. Law isn't like that. Law isn't descriptive, it's proscriptive. Law isn't trying to describe things in reality. It is trying to create reality. The law prescribes. That's what it does. It defines reality. It doesn't describe reality, it defines reality. It says if these things are true, then this results. It's an if-then statement. It's a logic game. It's definitions. If this is true, this follows. It's prescriptive. You can have any definitions that you want. And the definitions are argued about. And here's the critical part, though. The definitions actually, in this sense, matter intensely, right? Although the state of Maryland and the state of Texas and the state of Florida and the state of Alaska and the state of Hawaii, and for that matter, the nations of France and Spain and Japan and Australia and Uruguay, all undoubtedly have various versions of murder statutes. They are not the same. And you can't just say, well, we can look to any of them as our guiding star. All of them are equally good. No, that's not how they work. Each of them are prescriptive. Each of them define murder within their own respective territories. This is murder and nothing else. It is possible for the same underlying act to be criminal one place and not criminal another. You don't have that happen that often with something like murder, but it's possible. It's possible. Particularly, for example, in self-defense law, which would be the most notable example, right? So if I have the ability to retreat in complete safety, right? If I have the ability to retreat in complete safety, premise. If I have the ability to retreat in complete safety, premise, and I choose not to retreat, I'm screwed in Maryland, but I'm okay in Texas, right? Why? Because they have just said that's true. It is true because it is true. It is its own authority. It's sui generis. It generates its own rationale. There's nowhere left to go. There's nowhere higher up the chain to appeal to. Why is this true? Because it's true. Because we say it's true. In a constitutional republic, because we the people collectively vote for the people who define it to be true, because by our collective will it becomes true. We define reality. We bring it into existence. So you can't just say, oh, I'm going to ignore the language of the statute. I'm going to ignore the language of the charges. I'm going to get past the languages of the statute. I'm going to get past the languages of the charges. No, you're not. Especially and particularly, might I say, in the criminal law in particular, because the criminal law in particular is most notably to be narrowly construed. It is to be read narrowly. It is to be read tightly. It is to be read with deference to the defendant. It's the rule of lenity, right? The rule of leniency, if you prefer, right? The criminal law is to be narrowly construed. If there is ambiguity, if there are terms that are ambiguous, we interpret them in favor of the defendant. Not all terms are ambiguous just because you don't understand them, by the way, Todd. A lot of these terms, as I mentioned, have been understood for many, many hundreds of years, if not longer, in law. So the term, you may not completely understand what they're talking about, but yeah, they have a pretty good idea what they're talking about in these various statutes when they write them. You know, that's not always mean when we ambiguous, like, oh, it's not, well, this dictionary says this, and this dictionary says this, and this dictionary says this. And that's where I, as a lawyer, say, well, that's all real interesting. Watch me care. Do you see how much I care? Watch at my level of caring. This would be like where your cohort on your co-friend on the other stream, middle guy with the beard said, well, let me divide vigilante by appeal to some dictionary somewhere. And I'm over here as a lawyer like, no, that's not, no, you can't just do that. You're going to need some citations to some criminal code or something somewhere along the line, you know? So it's like, yeah, if we can get past those pesky definitions in the criminal code and in the charge, the exact thing that the state is required to prove, each and every element of which, every single one of them, right? Each element of the charge as laid out must be proven beyond a reasonable doubt. And if the charge is wrong, well, that's a pretty good basis to appeal, isn't it? The charge was legally incorrect, right? The jury instructions were wrong. The jury was charged with the wrong thing. It's like, oh, we can just get past the word, guess past it. It's okay. We wrote this word when we really meant this word. It's totally cool. Not when it comes to the law. Words kind of matter. You just can't be like, yeah, we're just going to ignore that. We're going to look past it. Those pesky words, you know, we understand what they're really talking about. If you do that in law normally, you are having a bad time. If you do that in the criminal law, in particular, but thank you for playing all those games, and no, don't do that.
I think this case really comes down to two questions. First question, was Kim Potter justified in using deadly force regardless of what she intended to do? If she was justified in using deadly force, it would not matter if she produced a firearm or a taser. Moving to the second question.
Are you sure? I mean, that was an argument from the defense. But are you sure? Right? Now, this was an issue that we had a lot of discussion on the law panel. And we had a huge debate on this. Like, are you sure? Because, hey, the lawyers aren't sure. The lawyers aren't sure about this answer. We're not sure. And, because it's like, so you have the right to do something intentionally. Can you do it accidentally? And the answer seems like it should be yes, logically, but, we're not 100%. Now, there might be case law out there that speaks to this issue. So if we were actually going to try to do this for real, we'd go start digging up some case law to see what it has to say. But you say this, well, if she was justified in using force, we'd be done. But that wasn't the charge. It wasn't part of the jury instructions. Are you saying the jury instructions were wrong? Are you saying the jury should have been told, hey, by the way, if she was authorized to use that firearm and to conduct that arrest, then we're just done here? I don't quite remember that instruction. Are you saying the instructions were wrong? Are you sure? Do you know something we don't know? I don't know, man.
Question: if she was not justified in using deadly force, was the production and firing of the pistol reckless, or was this simply an accident? On occasion, people make mistakes. Some of them are fatal. They believe they're doing one thing when they're actually doing another.
Nate Brody talked about this quite intelligently in his earlier video when he compared this to pedal confusion in cars, people mistaking the brake for the gas or vice versa, and it leading to accidents. And he says, and I tend to believe him, that this happens at least once a day, leading to an accident. This happens at least once a day in the United States, which seems very plausible. Someone mixes up the gas and brake even though they've been driving a long time. You know, things happen. The mind is a weird place. I believe it happens at least once a day leading to an accident. Now, whether or not you believe that's the cause of any particular accident, of course, is a try or a fact question. But the idea that it happens in the abstract seems plausible.
Not every incident is criminal. This is a mistake that other officers have made. There have been 15 other known cases in the United States where a police officer fires a pistol when their stated intention was to use their taser.
I believe that too.
Now moving to the next question. Was Kim Potter actually guilty of manslaughter? Let's take a look at the evidence both for and against the idea of guilt, starting with the inculpatory evidence. There's no question that Kim Potter shot and killed Daunte Wright. Wright was unarmed. Potter had been trained to distinguish a Glock 17 from a taser. There are quite a few differences between these two weapons. For example, the Glock weighs 2.11 pounds when fully loaded.
The fact that the hilt of the taser is black, because although the front of this thing looks bright yellow, if you're holding this thing out in front of you like a pistol, you might not see any of that, right? If you're holding this thing straight out in front of you like a pistol, the entire yellow part might be hidden by the frame of the gun. So all you have is this little yellow backstrap on there to distinguish between the Glock and the taser. So whoever at the taser company designed this by making the handle of this thing black, that seems like a product liability nightmare. I don't know whose lawyers over at Taser approved that one. I don't know whose lawyers over there at Taser approved that one. And I accidentally closed the window I was watching, so I have to reopen it. So if you will give me just a moment, please do not go. We will be right back.
.94 pounds. The Glock is black. The taser is yellow and black. The Glock was in a holster on her right side. The taser was in a holster on her left. The Glock has a safety feature on the trigger that can be felt with the index finger when the trigger is mounted.
Yeah, it can be, but if you're used to firing a Glock, you don't even notice it. I mean, yeah, if you're like paying attention, yeah, you'll notice it. But if you're used to firing Glocks, you'll never notice that on the trigger. Yeah, no. Have you ever fired a Glock, by the way, doctor? Just asking.
The taser does not have this feature. Moving to the exculpatory evidence, there is little question that Kim Potter's actions were unintentional. Potter only fired the Glock one time, as if she thought she was firing the taser. If she intended to fire her pistol, she would have fired more than once, as per her training.
I don't know if she would have or not. Usually the training is you shoot to stop the threat. I mean, I can't swear to their training. I'm sure it was in the testimony. And if we went back to the trial and listened, we could. But, I'm going to just go ahead and assume, because I feel pretty comfortable in the assumption because, hey, there's testimony out there. You can go listen to exactly the training. But I'm just going to go out on a limb, and I'm going to assume the training says you shoot to stop the threat. It probably doesn't say if you're going to shoot once, please shoot more than one time. It probably doesn't say, like, if you're planning on shooting once, please shoot a minimum of 2 times, or please shoot a minimum of 4 times. I'm going to guess the training doesn't say it is not okay to only fire your pistol once. Please fire a multiple of times. I'm going to guess the training says fire until the threat is stopped. That might be 1 time. That might be more than 1 time. But if she was really going to fire her gun, she would have fired more than once because her training told her to fire more than once. Really? How many times did her training tell her to fire? What was the minimum number of times? Yeah.
Her reaction after the shooting is also consistent with someone who recognized they had just made a mistake. Daunte Wright was breaking the law when he was shot. He was resisting arrest. Wright was attempting to put his vehicle in gear. Michael Johnson had reached into the car. If Wright had driven away, Johnson could have been injured or killed. One may consider the car to be a deadly weapon under those circumstances. Potter had never fired her Glock or her taser in the line of duty. This is a good thing in terms of public safety, but it also means she was not aware of how she would react to a situation if she had to use her firearm or taser. When considering all the evidence, do I think that Kim Potter was guilty? Here's how I look at this case.
Oh, please tell me.
I think that Potter was reckless by producing and firing a gun in the situation. However, I think there is reasonable doubt that she was guilty of manslaughter. There are 2 areas.
What? Hold on. What?
Potter had never fired her Glock or her taser in the line of duty. This is a good thing in terms of public safety, but it also means she was not aware of how she would react to a situation if she had to use her firearm or taser. When considering all the evidence, do I think that Kim Potter was guilty? Here's how I look at this case. I think that Potter was reckless by producing and firing a gun in the...
Okay. I think Kim Potter was reckless by holding and producing a gun. I accept your premise.
Situation. However, I think there is reasonable doubt that she was guilty of manslaughter.
What? How? What? You think Kim Potter is reckless in having and producing the firearm, but you think there was reasonable doubt as to Kim Potter being guilty of manslaughter, even though you find she was reckless of using and possessing the firearm, which is the predicate. How?
There are 2 areas of reasonable doubt from my point of view. 1, Daunte Wright was resisting arrest and may have endangered Sergeant Johnson. 2, the use of the word conscious in the definition for manslaughter is not consistent with her behavior. This word...
Then you don't get to reckless. You can't think all those things at the same time. You can't think all those things at the same time. If you think that the other officer was in danger and she was acting to protect him, then she wasn't reckless. If you think, hold on, the stupid is going in and out of my head. What did you just say?
I think there is reasonable doubt that she was guilty of manslaughter. There are two areas of reasonable doubt from my point of view. One, Dante Wright was resisting arrest and may have endangered Sergeant Johnson.
He was resisting arrest, so she was authorized to use force? And if she was endangering the sergeant, then deadly force would be authorized, which means it's not reckless, right? Tennessee v. Garner, you cannot shoot a suspect merely to stop them from escaping. You cannot shoot a suspect merely to stop them from escaping. If all they're doing is escaping, you can't shoot them. But if they're posing an imminent threat to themselves or others, namely in this case the officer, then you can use deadly force to effectuate that arrest. Note here, I said use deadly force, not kill them, because these are distinct legal concepts. Just because you're using deadly force doesn't necessarily mean they're going to die. It just poses an imminent threat of death or grievous bodily harm, right? That's deadly force, an imminent threat of death or grievous bodily harm. You're using the threat using deadly force. That does not imply that death will necessarily result. But if you believe that she was effecting an arrest, and that at the moment she was effecting an arrest, that the other officer was in imminent harm, then that would be a lawful use of deadly force to effectuate that arrest. Which means it isn't reckless. Okay.
2, the use of the word conscious in the definition for manslaughter is not consistent with her behavior. This word...
Yeah. Okay, so if you believe that it wasn't conscious, then it wasn't reckless. The word reckless means conscious disregard. That's or knowing disregard. Take your pick, but you kind of mean the same thing in this context, right? You can't know something if you're not conscious of it, right? There's a difference between like having some fact buried in the back of your brain somewhere, where like, oh, of course I knew that, and being aware of it at exactly that moment, right? If you're not aware of it at that moment, then you don't know it, even if it's stored in your long-term memory. In order for you to know it, you have to be conscious of it, right? There are a whole bunch of things that I theoretically know that I'm not conscious of them. So at this exact second, I don't know those things because I'm not. Now, if the subject came up, then I would then pull them into my short-term memory, and then, hey, suddenly I know them, but I don't have them in my short-term memory right now because the short-term memory can only hold so many things at once. So I don't know those things at the moment, but if you reminded me of them, I'd know them very quickly. But if you think that she wasn't conscious of it, she can't have conscious disregard. So it's not reckless. So she wasn't reckless. You're saying, hey, consciousness is inconsistent with how she acted, but I can still find recklessness. No, not really. No.
Implies that she was aware and knowledgeable about her situation. Yet the prosecution admitted that her actions were not intentional. Technically,
there is a difference between those two things, by the way. So as long as we're doing some nice legal education, right? It can be a fine difference, well, depending on your point of view. But there is a difference between intentional and knowing, right? There's a difference. There's a very fine difference sometimes. But there are three different states here, right? Recklessness, knowingness, and intentionality. All involve knowledge of some kind, but they all involve a little bit more. So let's talk about the technical differences between recklessness, knowingness, and intentionality, right? In the case of recklessness, I am knowingly disregarding a risk. I know the risk exists. I don't necessarily know what will occur, although I might know that something will occur, but not necessarily what. Right? Or I have knowledge, or basically I have knowledge of an extreme risk, right? Driving drunk, driving at driving at 150 miles an hour on the highway, right? I know that that's a bad idea. I'm doing it anyway, right? That's recklessness, right? I'm not showing due care and due cautious, and I'm doing it with willful disregard of the risk, right? So that's recklessness. Knowledge is I know a specific outcome will occur, but not necessarily I want it to occur. There can be a fine distinction, right? I know something will occur, but not that I want it to occur. So what would be a good example? I know that I know that if I sabotage your car, it means you won't be able to do XYZ. But I don't necessarily want you to not be able to do XYZ. I just know that you won't be able to. I just want to sabotage your car, right? I just want to sabotage your car for the purpose of sabotaging your car. I know that if I do that, it means that you won't be able to get to work that day. But I don't really care about that. I just want to sabotage your car, right? Yeah, there you go. I take a knife and I slash your tires. I do it because I want to slash your tires. I somewhere know in the back of my mind that means you won't get to work that day. That wasn't really my desired for outcome. It wasn't what I wasn't trying to prevent you from getting to work. I just wanted to sabotage your car, right? So that's knowing. I did a thing knowing a thing would occur. And then intentionality is the next step beyond that. Like, I wanted that particular outcome. So in this case, yeah, I wanted to prevent you from getting to work. That was my goal and purpose. I did it for that reason. So there's a distinction between knowing and intending, right? I know this will occur. I don't particularly want it to occur necessarily, but I know it will occur, versus I want that outcome to occur. So that's the distinction between recklessness, knowingness, and intentionality, right? I'm willfully disregarding something bad will happen. I know something bad will happen. I want that particular bad thing to happen. Maybe that's the short way of thinking about it, right? So there is a distinguishment there between those three states. Okay.
I suppose a behavior can be both conscious and unintentional.
No.
Like somebody could be impaired, so they're aware of what's going on to some degree, but they're not acting with intent.
Well, there the law has you covered, right? Because the law says the intent came at the time you imbibed the substance. Now, this, of course, assumes that you took it voluntarily. This is voluntary intoxication, right? It's also the difference between general intent crime and specific intent crimes, where you do get away with this or you don't get away with this. So some crimes are specific intent crimes. Some crimes are general intent crimes. So I take a bunch of alcohol, right, and it impairs my mental state. If it's a general intent crime, I can't use the fact I took alcohol to defeat the mental state, because I knew I took the alcohol, right? If someone drugged me and I didn't know about it, then we're in a whole different can of worms, right? This all assumes I did it voluntarily or knowingly. So if I did something knowingly that put me in an impaired state, then I take the responsibility. If it's a general intent crime, the intent was formed at the moment I consumed the substance. In specific intent crimes, you can get away with it because you have to actually form specific intent to do the specific things. And being intoxicated can be a defense in those situations. So there are some distinguishments between general intent and specific intent crimes. But even in general intent crimes, we're not saying you didn't have intent. We're just saying that your intent fell at the point you consumed the alcohol. So that was when your intent happened. And then you kind of took the rest for a ride at that point.
But for the most part, this is splitting hairs. If somebody is acting consciously, they are acting intentionally. I think whoever wrote this law committed manslaughter against the construct of clear writing.
No. There's a difference. There's a difference between recklessness, knowing, and intentionality. I'm willfully disregarding a thing that will occur. I know it will occur. I want it to occur. Right? In the case of recklessness, I don't have to specifically know that a particular thing will occur. I just have to know that I'm taking on the risk consciously in blatant disregard, as opposed to negligence where I don't have that knowledge. right? Speeding at 110 miles an hour. I know I'm doing it, right? I'm willfully disregarding that risk, right? But I don't necessarily know what will happen. I mean, we can make reasonable projections about what might happen, but strictly speaking, I don't know. I'm just, I'm just doing something with the reckless thought that it might occur. Knowledge is I know a particular thing will occur. I'm doing this with the knowledge that something will occur. And intent is I want it to occur. So there's no problem here. It's just that, you say you're slicing it pretty thin, but these ideas of mental states are well baked into law. They're well baked into the model penal code. These are not strange concepts. Recklessness is the devil may care, slip shot, just wanton laughing in the face of the rain and kind of thing. It's like it can be maniacal. It can be just very basically any idiot looking at you knows, well, something bad's going to happen. We may not know exactly what, but something bad's going to happen. That's recklessness. Knowledge is we know the particular thing that's going to happen. And intention is you want the particular thing to happen. They didn't commit crimes against drafting. It's fine. It's fine. These are not, not a, yeah.
If this shooting occurred in another state, where the law was written in a logical way, and Dante Wright did not resist arrest, then I would say that Potter was guilty beyond a reasonable doubt of first-degree manslaughter. Without the two reasonable doubts that I mentioned, Kim Potter's entire defensive strategy was essentially the whoops defense. I pulled and fired my gun by accident. Whoops, sorry about that. This defense is insufficient.
No, it's really not, actually. The whoops defense, as otherwise we know it, is called mistake of fact. So, yeah, take your pick, actually. Well, it's strictly speaking, depends on if we're attacking the mental state or we're attacking the action state. So, mistake of fact only applies if we're attacking the action. But either way, we're trying to nullify an element of the crime, right? We're trying to nullify the intent behind it, or we're trying to nullify the thing we did. So, whoops is not recklessness. It might be negligence. Right, it might be that, but yes. It might, yeah. Hold on, I have to ban somebody real fast. Hold on. Talk amongst yourselves. There we go. That's much better. So now, having taken care of that, let's go back to other things.
I think that the bottom line of this case is that there are some mistakes a police officer simply cannot make. This wasn't like pushing the wrong pedal in a car or pulling out cash when one intended to pay with a credit card. This was a situation of life and death. She was responsible to deploy the correct weapon. Not doing so is reckless. This is a crime without intent. I think it's reasonable to believe that she was so focused on the threat, so wrapped up in the fear, that it never occurred to her that she had retrieved her pistol instead of her taser.
If it never occurred to her that she didn't retrieve her taser instead of her pistol, if it didn't occur to her, she wasn't conscious. If she wasn't conscious, she didn't have disregard. She didn't form the men's state. She didn't form the mens rea. She didn't form the mental state of recklessness. She did not have the conscious disregard. All that crap. Yeah.
I think she was not cut out to be a police officer, and this was only discovered at the worst possible time. She was simply not calm.
Officer? I mean, she made a mistake that was painful, but why isn't she a good officer? She went 25 years without a single complaint, a single problem, without using her weapon, and yeah, all kinds of things.
And controlled under pressure. Moving to the last question, Did Kim Potter help herself by testifying in her own defense?
Probably
There have
not.
been a number of negative reactions to her tearful testimony. In particular, how she became suddenly dramatic at some points, but she was calm and calculated at others. I think Kim Potter made a few mistakes during her testimony. She minimized the severity of what Daunte Wright was doing to get pulled over in the first place, saying that if she was alone, she wouldn't have bothered to pull him over at all. And she minimized his outstanding warrant, referring to his crimes as petty. Even still, I do think that Potter helped herself by testifying, although clearly it wasn't enough to sway the jury.
Yeah, I don't really think she helped herself that much by testifying. I can't speak to how much experience she has testifying in her career. Police usually do pretty good, but in her particular case, I don't think she did herself any particular favors. I think she definitely weakened herself on her case, and she might have been better off not testifying, but it's a harder call than, for example, Kyle Rittenhouse, where I was losing my complete shit when Kyle was testifying. I'm like, nah. But it's a harder call here, even though it led to different results. So, we try to judge things based on the time because that's all we can do things based on. We don't try to look things through hindsight, but it was a questionable call in this situation.
Her dramatic crying and carrying on when talking about the shooting could have been convincing. It was a little over the top and forced, but it may have been genuine. I think the struggle for the prosecution, as far as Kim Potter's testimony, was that this case was not about inconsistencies. Therefore, the value of a clever cross-examination was greatly reduced. No one disagrees as to the facts of this case, so they were not going to catch her in some type of massive deception. This is all about trying to read the mind of Kim Potter, which no one can do. Now moving to the lessons learned. Lesson number...
That's what juries do. I mean, that's what juries do with their time is try to determine what mind is. I mean, that it's the best system we have, is that juries try to determine what was going through your mind at the time, or what should have been going through your mind, without the benefit of hindsight, which is where the juries kind of screw up, because they have a particularly bad ability to look at things without the benefit of hindsight, because they're like, well, what I would have done, it's like, yeah, probably not. No.
Number one is to avoid resisting arrest. The fact that police officers carry guns can be frightening sometimes. Unlike citizens with guns, police officers are given authority and encouraged to use guns in a broad variety of circumstances. As a group, sometimes police officers can be paranoid. They take on an us against them mentality. One tip for surviving encounters with law enforcement is not to commit a felony or a misdemeanor in front of them. It's actually a good idea to never commit a felony or a misdemeanor under any circumstances, but it is particularly dangerous to do right in front of a police officer.
Yeah.
Lesson number two, not everybody is cut out to be a police officer. I think very few people actually have a personality for that profession. Kim Potter simply didn't have enough restraint or good judgment. At some point, her supervisors should have recognized this.
How? On what basis would her supervisor have recognized it? Her supervisor, she had a clean record for 25 years. Head of the union, everyone seemed to love her. No complaints of any kind on the record, no history. On what basis should her supervisor have realized this? Magic? I mean, how?
Some people simply can't handle the responsibility of possessing a firearm. Even after shooting Wright, Potter couldn't control her emotions and essentially admitted that she was headed to prison. Emotions rarely give people the right answer to any problem, although I suppose technically that particular emotional outburst did accurately predict the outcome. At some point,
What's this?
her supervisors should have recognized this. Some people simply can't handle the responsibility of possessing a firearm. Even after shooting Wright, Potter couldn't control her emotions and essentially...
What? What? Even after shooting Wright, she couldn't control her emotions. She didn't, as we've been saying for some time at this point, she didn't intend to shoot him. So she has an emotional reaction because that wasn't what she meant to do. She was emotional because something had happened that she didn't want to happen. And she's a bad police officer for having emotions in this circumstance. Are we thinking that the officer should have just been like, oh, okay. Well, that's unfortunate. I moved on. It's bad to have emotions when you've just shot someone when you did so unconsciously. I don't know.
They admitted that she was headed to prison. Emotions rarely give people the right answer to any problem, although I suppose technically that particular emotional outburst did accurately predict the outcome.
What?
Those are my thoughts in the case of Dante Wright and Kim Potter. Please put any opinions and thoughts in the comment section. They always generate an interesting dialogue.
Well, I won't put any comments in your opinion section, but I will make an entire video reviewing your comments and your apparent confusion over legal standards. Not for nothing, but I would imagine that you've got to have some lawyers in your circle of friends, and maybe one of them could help with some of the legal details. When you're commenting about legal cases and you're saying things that don't make sense or are contradictory or otherwise confused, it's really really strange to me. So I don't know. It's a little weird. Let me check the super chats that have come in, and let me check other comments and see what else there is for us to talk about today. $20 from Far Out Aliens, who said smash the like button. Yes, smash the like button indeed. Stephanie says, I don't know if you've noticed, but after we went with him the panel discussion, they haven't posted a single episode since. That's hilarious. I had not noticed, Stephanie. That's hilarious. Stephanie suggested this topic, and she also suggested the one where we did the panel discussion. Stephanie has been doing wonders for the channel in recommending various stuff. Almost all of her stuff has been gold. The stuff that she's recommended, she's done wonders in terms of getting us some stuff that's been really interesting to analyze. So thanks as always to Stephanie for her extensive behind the scenes work, which is always appreciated. Super chat $20 from Alicia Cormy. Merry Christmas, Uncivil. Merry Christmas, Alicia. Thank you for your work. Are the prosecutors pursuing a greater than max sentence? That's not possible. Could they get to a life sentence through Blakely? No. You can't go past the statutory maximum. The statutory maximum is the maximum. So yeah, no, the maximum possible here is 15 years. So all that Blakely and anything else can do for you is 15. So they're gonna, we know what they're gonna write before we even, we know what they're gonna write. She's a well-trained officer. She had all this training. She went to all these classes. She had all this supervision. Showed she acted under color of law and her duties and blah 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 blah. And and then the defense is gonna say, well, this was an accident. It didn't show intent. She has a clean record, and who knows what the judge does after that. I think the right answer here is probably less than 5 years, but we'll see what's going to happen. It's the judge's call. It's the judge's call. They say tell it to the judge for a reason, right? There's a lot of yeah, I did get my present from my parents. I'm actually wearing one of my presents from my parents. They got me this shirt. But yeah, it's who knows what will happen. We will see. Now, it was interesting because I was talking to Nate the lawyer a little bit today. I couldn't talk to him for very long because I was working today, and it was stressing me out and stuff, but I took 5 minutes in the middle of my day to talk to him. which is, was because I was like in between things, so I could take the call, but I couldn't talk to him very long. In any case, he seems to think there's odds for appeal based on the prosecutor's mischaracterizations and misstatements of law. I think he has a point. I told Nate to tell his audience not to get too excited, though, because the baseline reversal rate for a conviction on appeal is 2%. So if we think it's a good case, maybe that means it's like 4%. So hey, so I wouldn't get too excited, but there's some chances. Let's see if there's any questions. Do what you need to do. It's not like you and Nate are perpetually late for every single stream. Thanks. I unsub from Todd when he repeatedly told a lie that Kyle Rittenhouse has ties to the white supremacists. Yeah. Can they use what Todd says in a video on appeal? No. Todd's an idiot and a fool on a stage. So, no. The X26 model was all yellow, including the handle. Not the one they were using, I don't believe. They say they're holding the gun in front of her face was really at chest level. Well, it was in front of her face. It's just that she's looking down, right? Because her target is down. So it is in front of her face. It's just that her face is also looking down. But yeah. Why did I choose the name Uncivil Law? Why not? It's a good name. Uncivil Law. NJ Native says, the jury and so many others do not agree with you. The officer was non-danger. Right. It was his premise, not mine. It was his premise, not mine. I was saying if you believe that, you can't believe recklessness. So, yeah. You're incorrect and the wrong, even politely had time to shut the car door. I was his premise, not mine. Alexander Ragnar. But drawing something is an intentional act. Yeah. One that almost comes with the risk of confusion. She knows that by not confirming 6 seconds she disregarded. This implies that every police officer who carries both a taser and a pistol is in a constant risk of confusion and is engaging in reckless conduct by doing both, which is, I don't think, a great conclusion. The Let's Go Brandon guy got outed by MSN mainstream media. Who's surprised? Real Life with Michelle and Rob says, I'm in Warren, Ohio. I saw your video about Santa. I know the officer Eric Merkel that stopped Santa. He's the chief of police. Well, give him a lump of coal from Uncivil Law. It's never too late, man. Tracy says, will you be covering Critical K case in the future? We've been covering it to some degree, if you mean the one with Critical K. That's Rabinowitz, right? Critical K? We covered that case. Critical K died. Samantha Rabinowitz, that's Critical K, right? She died. We covered that case. Her case was dismissed with prejudice. David Wellman, Merry Christmas. Merry Christmas to you too. Would she have legally been grounded in using her firearm and establishing use of force? Yeah, I think so. Critical K is not Samantha Rabinowitz. Who is it? She's here. She was here for the tea. Okay, yeah. So that's Yax. Critical K is Karen Yax. We've covered that case too. Yeah, that case is a whole bunch of pain, but we've definitely covered that case as well. That's a mess. Critical is Yax. Yeah. We've covered that case. We'll cover more in the future. We've covered that case. She lost her motion to get the case yeeted. I think we covered that decision, and now we're just waiting for more things to happen. So yeah, we'll continue covering it. Yeah. Anything else before we sort of sign off for the day? Thank you for all the people who super chatted, by the way, and the people that are here, the 677 of you who are currently here. If the people who are here would be so kind as to subscribe, if they've not done so already, we are trying to hit 50,000 subscribers, and we got 3,000 subscribers left to go. So if you haven't subscribed already, if you'd be so kind is to hit the subscribe button and help the channel grow, it would be really appreciated. If you haven't liked it already, like it, all that good stuff. Hope you meet sleep with Ty. Yeah, that'd be cool. Yeah. And thanks to Stephanie for being our mod throughout the evening. She's always wonderful here as a mod, and we do appreciate her being here, particularly since no one else seemed to show up for some reason. But, you know, whatever. I mean, I did announce this video like 7 hours ago or something, 8 hours ago, but, you know, whatever. Can we cover Fraze versus Illinois in regard to vaccine mandates? Maybe. I'll look into it. Yeah, Stephanie is a great contributor to the channel. Well, I'm going to sign off for now. If you haven't subscribed, subscribe. If you haven't given a like, please remember to check us out. Terminal Insanity gets banned. Not as much as me, man. And until there, my friends, I hope all's well. Cheers and goodbye.